and you did nothing. Let me ask you this. Do you not take this seriously at all?
I do take it serious. I'm busy. I'm a very busy person. It's kind of inconvenient for me.
This is all inconvenient. She's too busy and it's inconvenient. Really, this isn't all about you. You made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident.
This woman walks into court with an attitude that suggests she isn't taking the situation very seriously, and it quickly catches everyone's attention. She has already built up more than 15 probation violations, yet she's now telling the judge that the court's conditions are simply too inconvenient for her to follow. Instead of helping her case, that explanation makes it seem like she doesn't fully respect the seriousness of the court's orders. Her original charge involves drunk driving, which is already considered a serious and dangerous offense. Because of that, the court expects strict compliance with probation rules. Treating those conditions casually only makes the situation worse. Judge Simpson appears unimpressed and is listening closely, but it's clear the repeated violations are becoming a major issue. When someone continues to break the terms set by the court, the judge may feel there are very few options left. The way she's presenting herself makes this moment in court particularly intense. Do you think she realizes how serious the situation has become? Let's keep watching and see how it unfolds.
The bond violation, or sentencing on the violation. Did you get the new report?
Yes, I did, Your Honor.
Is there anything you want to say before I?
Yes. But I'd like to start off. Ms. Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow, and she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to community corrections, but because she had her child with her, community corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She is working full-time, works at EHM Senior Solutions in Saline. She's been there for the last 4 years. She also is enrolled inside school full-time, inside the nursing program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
The problem that I have, Ms. Wilson, is that on the 17th, you admitted to the violations. We set the sentencing out to today. In the interim, because there was a dirty flow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Can I talk?
Yeah.
I worked both.
What'd you say?
I work Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad, or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, not watching.
Tell me how I know that you weren't drinking over the week. I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober line, right? The alleged blood alcohol content was 0.085. There was an accident. During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said, because I got the tether.
Oh, I know.
Oh.
5 days late. So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober link either.
Yeah, because the device locked. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right.
And she did inform me of that. She did inform me of that yesterday when she tried to test on the sober link. On the 18th, it gave her an error that it had to be reset.
And you did nothing.
Bring my kid in there, I can't.
But you did nothing. And then, let me ask you this. Do you not take this seriously at all?
I do take it serious. I'm busy. I'm a very busy person.
Okay.
And that's not an excuse,
We all are.
but it's kind of inconvenient for me. That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient.
The moment she told the judge she was too busy to get her tether installed, the tone of the entire hearing changed. To a judge, that kind of statement can sound like a direct dismissal of the court's order. Court orders aren't optional. When someone openly admits they didn't follow a requirement because it was inconvenient, it can quickly damage their credibility in front of the court on a personal level. It's understandable that someone might not like the idea of wearing a tether. It can feel uncomfortable and restrictive, but refusing to comply with it only makes the situation worse. Judges hear explanations and excuses every day, so when one sounds like it's minimizing the court's authority, any remaining sympathy can disappear quickly. Ironically, a tether is usually considered one of the lighter restrictions available. By refusing it, she may be pushing the court toward considering stronger consequences. Legally, these conditions are part of the bond agreement. If someone fails to follow them, the judge has the authority to revoke that bond entirely. What makes this moment stand out is how confidently she said it, almost as if she expected the judge to accept the explanation. Instead, you can see Judge Simpson carefully watching and processing what she just admitted. It's an uncomfortable moment, but also a revealing one about how seriously the court views compliance with its orders.
It's all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient. But if true, no one in this room is the cause of that inconvenience except you.
I think her youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her.
But Ms. Coons, I appreciate that. But at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, well, let's say 20 violations of basically, well, actually it's not quite that many, it's about 15 violations of the program itself in terms of when she was supposed to blow. Then on the next one, she drank. Then even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled. On the 12th, she didn't test on 2 occasions for her testing that day between 7 and 10 a.m. and 2 to 5 p.m. She didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then on that day still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month. And then she appears before me on the 17th. I give her a break by not remanding her and tell her that she has to get a tether. And then I get here, I'm now and set this out to the 24th, and now I get here and she's too busy and it's inconvenient. Really.
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just, I don't get frustrated.
Yeah. Well, she does have the tether on, so it would negate any further missed test, Your Honor. If she's able to continue on to bench.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But when we spoke, she did state that she'd like to continue this case. She'd like to stay out on bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed a court date.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests. You missed going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th. You didn't do it.
Many people overlook the fact that probation and bond are essentially a second chance. The court is allowing someone to remain free while proving they can follow the rules, but that opportunity comes with responsibility. What judges are really looking for is compliance, not explanations. When someone tells a judge they were too busy to follow a court order, it can come across as if the court's rules simply weren't a priority. Trust plays a huge role in how the system works. Courts rely on the belief that someone will show up when required and follow the conditions set for them. If that trust disappears, the judge may feel there's little reason to keep giving someone the benefit of the doubt. Probation is often designed as a test period. It gives someone the chance to show they can handle their responsibilities while remaining in the community. If the rules are repeatedly broken, the court may decide that stronger consequences are necessary, and the impact can go beyond the courtroom. Violations can affect future opportunities, including employment, housing, and other parts of daily life. There's also another factor. Sometimes judges know that many people are watching these hearings. The way they respond can send a message about how seriously the court expects its orders to be taken. What do you think? Is it fair for judges to make an example in situations like this? Or should every case be handled strictly on an individual basis? Share your thoughts.
In fact, so that we're also clear on the 19th, on the 18th, community corrections talked to you that day. Mm-hmm. And you told them that you would report to them on the 19th.
Yes, because I thought I could, but I couldn't.
That's a Friday.
Mm-hmm.
and you didn't report on the 19th, you didn't call to reschedule or offer to them, according to this report, any explanation for your not reporting. You just didn't show up. And then on Monday, even if I accept your rationale that you were working, and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't, Monday, you weren't working, and you still didn't go until late, actually after the agent that's assigned to your case at Community Corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether, because otherwise you'd be showing up today with no tether. And mind you, that the person that did that did it after the agent that's assigned to your case had terminated you from Community Corrections supervision because you weren't compliant. Anything else?
Nothing further, Your Honor.
Lady, you're going to have to learn to just pay attention. When court tells you to do something, you're going to have to do it. This isn't all about you. Everybody has busy lives. And I can appreciate it when I see people try. What I see in this report is somebody that's not trying. That somebody is putting other priorities ahead of what your obligation to this court is and what your obligation to this case is. And again, allegedly, you made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident. It's the sentence of the court. Defendant remanded to the Washtenaw County Jail to serve 5 days for the violations to date. Mr. Allen, you may take her.
This case is a good reminder that court hearings aren't really about the dramatic moments we see in the room. In the end, the key question for the court is simple. Can this person be trusted to follow the rules outside the courtroom? Most judges don't want to send people to jail if they don't have to. But when someone repeatedly ignores the court's orders, the judge has to think about public safety and accountability. Another thing many people don't realize is that jail time isn't always just about punishment. Sometimes it's meant to be a strong warning, a moment that shows the person the situation is serious and that future violations will bring even heavier consequences. The effects can also go far beyond the courtroom. A violation can create problems in everyday life, such as issues with work, housing opportunities, or even driving privileges. What might seem like a small decision in the moment can turn into long-term challenges later. What stood out here is how Judge Simpson handled the situation. He didn't raise his voice or turn the moment into a long lecture. Instead, he simply made his decision and moved forward. That calm approach can sometimes carry more weight than anger. IT raises an interesting question. Are consequences more effective when they're delivered calmly and firmly, or when they come with strong emotion? Thanks for watching, and feel free to share your thoughts.